No worries. What I thought was interesting that caught my eye this week was an ABA journal story, and I will paste that in the chat. And what and I really liked it because it covers this intersection of everyone getting vaccinated and testifying remotely in virtual practice of law. And so essentially it was about a class action, and the defense counsel, which was a school, was trying to allow its witnesses to testify remotely. And the plaintiff's counsel said, listen, everyone's getting vaccinated. They need to, I would like the judge to inquire as to whether they're vaccinated. And if they are, then what is it that they're necessarily worried about in terms of coming in and testifying in person? Because testifying in person provides a more, it's just a better way to cross-examine someone and elicit testimony. And I thought it was really interesting because we're at this like point in time where people are getting vaccinated, and some people for strategic reasons are going to prefer remote testimony and are probably going to try to use that as a wedge in a case. And plaintiff's counsel was having none of it and saying, listen, if they're vaccinated, they're going to have to explain what they're actually nervous about because the vaccines are so effective, and otherwise they have to come and testify in person. And I just thought it was a real interesting sort of point in time that this issue is being used, and it's a strategic decision. So I just wanted to, I posted in the chat, and I thought it was really interesting and wanted to highlight that.
All the more reason not to get your vaccination card laminated, Steve.
Yeah, you know, Nikki, it's an interesting point because, you know, in addition to sort of the safety sort of concerns about coming to testify, there's the disruption and cost concerns. You know, if you have an expert that's across the country, you know, having that expert come and testify in Louisville, Kentucky could be phenomenally expensive because you got the travel to and from, and then you've got this sort of, you never know exactly when the expert's going to go on the stand, right? I mean, it could be 10 o'clock, it could be 2 o'clock, it could be tomorrow, it could be next week. And you know, that's one piece of it. And then in smaller cases, you have, you know, even parties, but certainly witnesses that, you know, they'd be much more willing to testify if they could do it in a more convenient sort of way. So it's kind of like, how do you balance this sort of need to get the testimony in with convenience and all of that? I tend to think, you know, the in-person interaction deal is maybe a little bit overblown in a lot of ways. And I think there's some research that would maybe support some of that, but certainly the inconvenience of having to, an expense of having to testify and appear live is pretty significant. When you think about it, all the way around.
Yeah, I wonder if some people would just say that's like private health information and I'm willing to testify, just not go into the courtroom or to the deposition where we're having it. Like, you know, like that's personal information. You know, I know with Nikki, you're talking about like maybe it could be like strategy or something like that, but I could see maybe some people saying, well, that's personal health information. Like I'm willing to testify, you know, I'll just do it remotely or something like that. So I can see some people just having a little bit of pushback of like, you know, I'm still willing to do it, but, you know, I'm not willing to give up like my health status or vaccination status to just go in person to do it.
You know, and there's another piece of this I just thought of, you know, in civil litigation, you know, there's a great reluctance by courts to call chief executive officers to testify. I mean, the CEO of Google has more important things to do than come and testify, mainly because of the disruption. But I wonder now that it's easier to testify, whether we'll see some sort of loosening of the judicial reluctance to make those kinds of people appear before juries or appear before judges because of it's much more convenient now. That'll be an interesting fallout, I think, will come from all this.
I think it's I think, Victoria, you raised a really interesting issue, and I wonder if it'd be like an in limine issue, like they'd have to tell the judge in limine, because the argument was that they're uncomfortable testifying in person for safety reasons. And so they're just sort of calling their bluff and saying, listen, if you're vaccinated, how worried can you be? But then I also, but that's a good point in terms of not wanting to publicize your health status. And then Steve raised the point that I hadn't really given too much thought to, but in terms of, but that I think is really interesting as well in terms of strategy from a cost perspective. You know, the defense attorneys are usually billing by the hour, and all the costs are being passed on either to the insurance company or to the client. And then plaintiffs don't have to worry they have to worry because they're fronting the cost, but at the end of the day, hopefully they're going to recover a lot of that. But there may be a little bit of a back and forth there in terms of trying to make it more expensive to defend the case, because usually the case gets to a certain point in terms of how expensive it is to defend it, and it will cause the defense to reconsider negotiating a settlement. And so I wonder if there was a little bit of that in play as well, in terms of trying to get all 15 witnesses to come and testify in person and the expense that's associated with that, as you've mentioned. So I just think it's interesting, though, that to see the sort of intersection of the vaccine and virtual testimony as we're starting to phase out of the necessity for virtual testimony, and then how they're using this sort of strategically, presumably, within this litigation.
So, Niki, do you think that that's a kind of a dangerous ploy, especially if in the next case it works for you the other way to have your folks come in remote? So, and you're already on record opposing that vehemently.
Well, the class action, you're going to have to assume, I think, that hopefully I would think the likelihood that it's going to be in front of that particular judge in that particular court is not all that likely, but but these days everything is available through Pacer and through all the AI analytics software. So I assume that information can be dug up pretty easily compared to the old days when you didn't know as often. So that's a really good point. I think you're taking a risk when you do that. But then again, you may just be assuming you're going to get to a point where remote testimony is just not a necessity, and it's almost like a luxury. I don't know.
As a local reporter, I would be very happy to point those hypocrisies out in coverage.
Well, hopefully, see, this is why we just need to get rid of legal technology that makes it so easy for people to find this. The harder it was, the easier it was to defend clients. Legal tech, you're destroying our ability to advocate zealously at all
public
times.
Information was not public.
And yeah, well, I mean, public information still, at least at the state level, we've had this conversation on this show before. Go back and listen to some of the archives about how public information still isn't public in certain states, like being able to show up on a Tuesday with a form in triplicate in order to see a public record is not really public.
Yep.